A Missouri appeals court hears a case over local government stacking sales tax on marijuana, you guys. The court debate on Tuesday over how Missouri marijuana products got taxed statewide sounded similar to a grammar class on conjunctions and comma placement, you guys. The constitutional amendment voters approved back in 2022 legalizing adult use marijuana allowed local governments to impose additional sales tax on the products. And the big question before the three-judge panel of the Missouri Court of Appeals Eastern District on Tuesday was, what did voters intend by, in quotes, local government, you guys? Attorneys for St. Louis and St. Charles counties argued that the word "and," in quotation marks, is key and the definition laid out in the constitutional amendment. In states that, in quotes, local government means, in quotes, in the case of an incorporated area, a village, town, or city, and in the case of an unincorporated area, a county. The county asked the appellate judges to uphold a lower court's interpretation back in May that both a county and a local municipality can impose a 3% sales tax at dispensaries in their jurisdictions. And however, Florissant-based dispensary Robust Missouri 3 LLC argued that the comma placement is key, you guys. Interesting. In a quote, while and typically functions as a conjunction, here it connects two distinct clauses, one for incorporated areas and one for unincorporated areas under the framework of in the case of, which delineates separate alternatives, states the robust reply brief. Attorneys for Robust said on Tuesday that the voters did not intend for two local governments, in its case, St. Louis County and the city of Florissant, to both add taxes, resulting in a 14.988% sales tax rate. To put that in perspective, the highest adult use marijuana tax in Missouri is in Florissant's neighboring cities of Hazelwood and St. Anne, with 17.988% tax. Looking beyond the grammar, appellate judges asked about the possibility of absurd outcomes that St. Louis County Circuit Judge Brian May wrote about in his ruling. If the court accepted Robust's definition of local government, and May wrote that if Robust's interpretation of the amendment were accepted, in quotes, then a municipality or city would essentially be given carte blanche to ignore any county ordinance or regulation, including those related to public health and safety, wholly unrelated to the taxing issue, they say, end quote. May was largely talking about public health regulations because public health and Florissant is regulated by St. Louis County. And on Tuesday, Judge Robert Clayton asked Robust attorney Eric Walter, in quotes, if we accept your definition, all those county regulations or everything else will be no longer acceptable, or these particular types of businesses, you guys. Both attorneys for the counties and Robust declined to comment on Tuesday's hearing, and following May's ruling, the Missouri Association of Counties Executive Director Steve Hobbs said the association has strongly advocated that counties have the ability to levy their own taxes. In a quote, the bulk of the counties around the state had gone to the voters and asked them to implement this tax, Hobbs told the Independent in May. And in quotes, and I think every one of them are approved for it. I think the ruling removes some uncertainty from those counties. And on the other side, leaders of those marijuana industries have called the effort to collect both taxes an unconstitutional money grab. I totally agree with them on that. That violates the terms of the amendment. Jack Carteretti, spokesperson for the Missouri Cannabis Trade Association, said the appellate judge on Tuesday seemed very prepared and well-versed on the issue. And in an additional quote, obviously much of the discussion centered around the definition of local government in Missouri's Constitution, which we saw as a good sign. And Cardelli said, as we enter year 2 of Missouri's cannabis consumers paying roughly $3 million more each month, and they should, we hope to bring customers relief as quickly as possible. A similar appeals case out of Buchan County is also pending, and St. Joseph Dispensary Vertical Enterprise sued Buchan County County Collector Peggy Campbell, arguing that it too would be irreparably harmed if both taxes were imposed. Also in May, Circuit Judge Daniel Kellogg ruled that the marijuana law does not limit the taxing power of counties within corporate limits of towns and cities. A hearing date for this case has not yet been set yet, you guys, and I can't wait to hear what you guys have to say about this, but I have a feeling I'm not going to be able to hear any of you guys.